We did not argue Blacker in the Supreme Court on behalf of the Secretary and the Canvassing Commission. But I think the answer to your question is this, that the judiciary obviously has the appellate power to review what a circuit court does. There is a constriction, however, and I think that constriction is picked up in the language of the Supreme Court, and that has to do with the concern in this kind of election having to do with presidential electors, which is different than the other kinds of elections, for instance, referred to as by Justice Anstead. And that is the language on page 6 of the slip that says, since Section 5 contains a principle of federal law that would assure finality of the state's determination if made pursuant to a state law in effect before the election, a legislative wish to take advantage of the safe harbor would counsel against any construction of the election code that Congress might deem to be a change in the law. So I suggest that is the restriction that you would have. The legislature has the power to select electors. In Florida, the legislature has allowed the people to make that choice. But I think, Mr. Chief Justice, that what you need to do is you need to be careful in terms of construing statutes or remedies to not do anything that would constitute a change in the law, because if that is done, then that places in jeopardy either the safe harbor, if the Supreme Court limits itself to that, or the concept that any kind of change of law is barred by Section 5. Why hasn't that been
accomplished in our previous decision that gave due regard to the fact that you have a federal scheme that has certain fixed dates or a calendar in place, and that we have interpreted the statute to be certain that the votes are counted and finally counted before that fixed date comes into play? Why doesn't that take care of that?
Justice Anstead, I don't think there's...
I don't know that you're saying that it doesn't. I'm asking you.
No, Justice Anstead, I think the problem is there's no way of reading Harris. I mean, Harris was not limited to dealing with presidential election contests, obviously. The Supreme Court of Florida was dealing with issues that had to do with the Florida Election Code.
And the Florida Election Code, as enacted by the legislature, is a single election code, is it not? That is that the Florida legislature, after submitting to the voters of Florida the authority to pick their presidential electors, has not said we're going to have one election code now to review that election, and we're going to have another election code to review all other elections. Have they?
Your Honor, the Florida Election Code is a short form for including all the various statutes that deal with elections in Florida. There is one collection of laws that deal with that, but there are different provisions that deal with presidential elections in 103 than deal with other elections. I think the difficult...
Well, in terms of any of the issues that we've been talking about, as far as counting votes and ballots and filing them and returns and all of those things, there is simply a single scheme, is there not?
Your Honor, I don't think that there really is. I think Harris is a substantial departure. If the test is...
Tell me where there is a separate scheme for considering the outcome of the electors for president. And this proceeding is a good example of this, and that is that we've had a contest, filed in the circuit court. Mm-hmm. Do you agree that the contest statute applies to the selection, the election by the people of Florida of their presidential electors?
I think that the contest statute can apply in this situation if it's applied properly.
Okay, does it apply?